Court calls the case of the people versus Portia. Is it Elledge?
This case opens fast, and Judge Simpson wastes no time calling the defendant forward. But don't let the calm start fool you. What unfolds here is a layered mix of addiction, missed court dates, conflicting explanations, and emotional fallout that hits hard by the end. Right from the start, we're watching a defendant step into a courtroom already carrying the weight of past mistakes. She isn't here to fight the charge. She's here to plead guilty to misdemeanor cocaine use, a decision that instantly sets the tone. Direct, raw, and heavy. As the assistant public defender clarifies the plea agreement, notice how Judge Simpson methodically ensures the defendant understands every consequence. The misdemeanor classification, the potential for up to a year in jail, the fines, and even the fact that he won't be her sentencing judge. That detail matters. It signals that today is about accountability, but the real decisions are still ahead in Judge Washington's courtroom. And yet, behind all the legal procedure, you can feel tension simmering. The judge wants clarity, the defense wants leniency, the defendant wants a chance to breathe. But as you'll soon see, the emotional core of this hearing is not the plea. It's the chaos that follows when questions about her missed court dates surface. Her explanations, the judge's skepticism, and the impending bond decision create one of the most emotionally explosive moments we've covered on this channel. Stay locked in, because what appears to be a routine plea hearing quickly turns into a powerful showdown about responsibility, consequence, and the high stakes of failing to appear in court. What happens next will absolutely grab you.
Assistant Public Defender Plea Anderson with the Ellis is approaching. We submitted a plea form. This will be a plea for misdemeanor use with no objection to 7411.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of use of cocaine. That is a misdemeanor punishable by up to 1 year incarceration, $2,000 fine plus court costs. Do you understand that?
Yes.
Ma'am, I also have to apprise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. Do you understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
I plead guilty.
All right. Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
All right. On August 17th, 2022, at the location of Holmes Road near Sweet Road, Ypsilanti Township, Washtenaw County, State of Michigan, did you have cocaine in your possession?
Yes.
Had you used it?
Yes.
Did you know what you were using was cocaine?
Yes.
Counsel, have I complied with the court rule?
This rapid-fire sequence of admissions is a textbook plea colloquy. Judge Simpson needs to lock down 3 elements: possession, use, and knowing intent. Her answers, short, resigned, almost monotone, tell a bigger story. She isn't fighting the facts, she's surrendering to them. And yet, these simple yes statements carry immense weight. Each one is a legal nail sealing her plea as valid, binding, and irreversible. But here's the twist. The calm acceptance in this moment will collide violently with her later emotional eruption once bond becomes the topic. It's a dramatic shift. 1 minute she's compliant, the next she's overwhelmed by everything at stake. This is where you, as a viewer, should start noticing the divide between legal reality and emotional strain. When someone pleads guilty, the legal system expects consistency, stability, and responsibility. But her later explanations, hospital stays, car accidents, jail time, paint a picture of someone pulled in every direction. Do you think she fully understood the consequences, or did the pressure push her into a plea she wasn't emotionally prepared for?
Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
7th at 10 a.m. for Judge Washington.
March 7th, 2024. At 9 a.m.
10 a.m.
10 a.m. before Judge Washington.
Thank you, Your Honor. And may I address our bond, please?
May counsel approach?
Yes.
I have children. I'm sorry. What happened that you recorded in April, but to February? I've been in the hospital. I've been in all kind of stuff. I was incarcerated in another jail. I was in Wayne County Jail. That's why I didn't come back the first time. That's where that warrant got.
Okay, and the court's question was, that there was a warrant that was issued for the defendant's failure to, she had a PR initially on this case. She didn't appear in April of 2023. She's not arraigned again by us until February of 2024.
This is the moment where the courtroom atmosphere shifts. Judge Simpson begins dissecting the timeline of her failure to appear, and suddenly the case becomes far more complicated than a simple drug plea. The defendant had a PR bond, essentially a trust-based release requiring only one thing: show up to court. When she didn't, the court issued a warrant, and that failure now looms over everything happening in this hearing. Her explanations, COVID, hospitalization, a car accident, and incarceration in another county, sound chaotic and overwhelming. But the judge's job is not to evaluate emotion, it's to evaluate reliability. And reliability is exactly what he doesn't see here. Months passed. No voluntary surrender. No follow-up. No attempt to clear the warrant. This raises a critical question for viewers. When someone faces multiple hardships, how much leniency should the justice system show? Should the court weigh her struggles more heavily, or must accountability come first?
And my question was, where was she? And then I'm going to have a follow-up question.
Okay, yes, Your Honor. So in April, there is some notes that she contacted our office that she had COVID and wasn't able to appear. It looks like that's the date that the warrant was issued. She indicates to me that she was in the hospital some time and she was in a car accident and also in custody in the Wayne County Jail. Do you remember the dates or how long you were in Wayne County?
I was in there 45 days.
How did she come back into custody?
I was in a car. I was in a car with someone and they was driving a stolen vehicle.
So you didn't turn yourself in, even after all that time. Motion for bond reduction denied. Bond will continue.
This is the emotional explosion point. When Judge Simpson denies the bond reduction, the defendant immediately reacts with confusion, frustration, and despair. Her comments, "Why would you tell me I was getting out?" and "My baby's birthday is on the 20th," reveal the crushing weight of her expectations versus reality. It's important to understand, bond decisions hinge on reliability and risk. And her history, missed court, a warrant, long absences, and no effort to turn herself in, convinces the judge she is not a candidate for reduced bond. Even though she insists she'll comply, the record tells a different story. Her emotional breakdown here is human, raw, and painful to watch. But courts operate on documented behavior, not promises. This is where legal logic and personal crisis collide. Would you agree with the judge, or do you think her circumstances justified more compassion?
I didn't, honestly, it was all that time went past. I honestly forgot, Your Honor, about this charge. I would come. I don't mind coming to court for it. That's why I'm pleading guilty for it.
Take it up with Judge Washington. My decision is bond denied.
Thank you.
Why would you sit there and have me plead guilty to this?
You still gonna get the.
I got all these other court dates. My baby birthday is on the 20th. Why would you tell me I was getting out of here?
You were getting out. I told you the judge has to make that decision.
Oh, I'm sorry, guys. My baby's about to be 2 years old and you playing with me like that, bro. Keep playing with me. Come on here, bro. You don't let my friend leave away. No. I'm about to miss my baby birthday, please. Bro, don't touch me. Don't touch me.
And it's gone. Court calls the case, People versus Brent Graves. Court does call the case, People versus Mark Rassman.
Morning, I'm Roderick K. Green, 33837. On behalf of Mr. Rossman, Your Honor, this is
Good morning, sir.
PCC. Good morning, Your Honor.
Sir, you need to face forward. Your name?
Mark Raven.
Your Honor, we just got discovered this morning and I have not had an opportunity to go over with my client. I'm asking for a 1 week adjournment for the PCC. Is that possible?
Yeah, it's possible, but okay.
The 15th, and I'd like to speak to bond if I may.
You may go ahead.
Your Honor, my client has no criminal record whatsoever. The bond is extremely high, $100,000. He has no criminal record whatsoever. Works with his dad in construction. I'd ask for at least, Your Honor, a 20,000, 10% bond. I think that's reasonable.
Probable cause conference is adjourned out a week to the 15th. It's 9 a.m. Response from the people.
It's true that the defendant does have no criminal record. However, it is 100,000 with 10% privilege in this case. As the basis for that bond request was the allegations, and then he showed up to his ex-girlfriend's house. He left his TV outside the house because he knew he was on the way and she didn't want to see him. When he arrived, he started banging on the door. She opened it a little bit. He pushed his way in, put his hands around her neck, pushed her across the room, and started yelling at her.
The tone of the hearing changes again as a new defendant's case begins, and this one escalates quickly. The allegations described here are extremely serious: forced entry, physical assault, choking, and aggression in the presence of another witness. Domestic violence cases often come down to credibility and context, but the prosecutor lays out a narrative that paints the defendant as a direct threat to the victim's safety. But what makes this moment especially significant is the pattern emerging: anger, escalation, loss of control. The judge must consider not only what happened, but what might happen if this defendant is released. Combine the physical violence with the threatening comments he allegedly made afterward, and the risk level spikes dramatically. The defense pushes back, arguing the case is overcharged and the bond excessive. But the judge's job is risk management, not just legal fairness. If you were in Judge Simpson's seat, would this description make you more cautious about lowering bond?
This was in front of the victim's brother, who tried to separate the two and stop the defendant. The police were called, but the thing that's the most concerning is the statement that he made on his way out, where he told the police that for the shit I'm being charged with now, I should leave that shit out. It's concerning that the initial incident of physical violence and aggression was not enough for the defendant. We are concerned that if he's out, he would immediately return to the victim's residence, not just by his own actions, but that's what he said.
Well, Your Honor, the parties used to live together. This is a domestic violence case at best. She opened the door, and he walked in. They used to live together. They lived together for 4 months, and they had only parted a week before. So he's overcharged, number one, and the bond is extremely high.
It's extremely high, but also, I guess, once after this incident, and he was arrested, he got to the jail and then started calling the victim in the case. Are you aware of that, Mr. Green?
Say that again, Your Honor. I probably.
And after he got to the jail, he started calling the victim immediately, and the magistrate was so he had to deny his phone privileges because of his repeated contact or attempted repeated contact with the victim in this case.
It's my understanding that the contact was simply for her to contact his parents because that was the only number that he knew. He actually lives in New Jersey.
Pardon?
I was saying he lived in New Jersey. His parents are in New Jersey, so he was calling her to contact his parents in Jersey, let him know that he was being locked up. But it was not of an assaultive nature at all, Your Honor. And certainly there was no.
Well, how long has he been in our state? Because I have a New Jersey address for him. I don't even have a Michigan address for him.
So they lived together in Michigan. Where'd you live in Ann Arbor?
3617 Van Court.
3617
Weeburn Court.
How long has he been in the state?
About a year, Your Honor. Year. They were living together, boyfriend, girlfriend.
Well, I understand that, but I have a New Jersey address for him. I don't have a Michigan address for him.
That's
Number
trans-
one. Number two, the other thing
3617
is,
Reburn Court, Your Honor.
pardon?
3617 Reburn Court.
Where the incident happened.
I guess the other aspect is that after, I mean, the comments that were made in this case, I think are a bit alarming. And then after being arrested, there's then contact with the victim in this case. And that is troublesome because I don't believe that, or at least leads the court to believe that if I were to release the defendant, that he would not be able to follow the court's orders regarding this.
Your Honor, if I may,
But there-
the address that is also being stated as the defendant's address is the victim's address and the occurrence of this, of where these events happened. So that just further exemplifies our concern for him returning and having additional contacts with the victim.
Your Honor, there was
Where
no,
would he go, Mr. Green? If he were released, where would he go?
Yeah, hotels. I can live with friends.
he's got friends here, Your Honor. He can go to a hotel. His parents
Well,
will put him on.
and, I mean, I may look at it again if there's an address that he goes to, but I'm disinclined to grant his release at this point.
But I'm just asking for a reduction, Your Honor, even a $20,000 10% bond, that's $2,000. That's a reasonable bond.
Well, I don't know
$100,000
that it's a
10% is
reasonable
unreasonable.
bond given the circumstances and the fact that I don't know that this defendant even resides really within this state, Mr. Green.
I
I mean,
understand.
that's part of my problem. I don't know where he will go. So at this time, he's coming back in a week. If I have additional information, I'll take a look at it again. But right now, motion for bond reductions denied. Bond will continue.
I'll get it to you, Your Honor. Thank you very much.
This final decision from Judge Simpson brings the hearing full circle. In both cases, one involving substance use and repeated absences, the other involving alleged domestic violence and post-arrest contact with the victim, the judge's guiding principle remains the same: protecting the integrity of the court process and ensuring community safety. His refusal to reduce bond reflects a consistent standard. When reliability is uncertain or risk appears elevated, leniency is not an option. Today's hearings highlight how quickly courtroom dynamics shift. A plea hearing that begins smoothly can unravel when past failures surface. A domestic case that seems straightforward becomes complicated when out-of-state residency and repeated victim contact enter the picture. Through it all, Judge Simpson grounds his rulings in documented facts, not emotion. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.